Hello, good afternoon, everyone. My name is Halley Auger. I'm an employment lawyer at Samfiru, Tumarkin. I'm located in Alberta. Here today to answer your questions regarding any employment matters. Before we get started, I want to talk about another thing that's rearing its ugly head in Alberta, and that is job application scams. So you may have heard in the news that there's a lot of people who are being asked to return to the office. Lots of companies, lots of banks, government agencies are having their employees return to the office. With that, obviously, there's a lot of employees who like working from home. I love working from home. I completely understand the sentiment. So what they're doing is they're now looking for remote opportunities online. Unfortunately, we've been hearing some feedback from some of our clients who are in the job search that there are job application scams going on out there. So we used to see this a lot during COVID. One of the job scams that was going around in COVID and maybe rearing its head again is when employers send you a check for an amount of money that you can go use to buy some home office equipment. So a desk, a laptop, a printer, etc. And what they do is they send a lump sum check and tell you to go buy the equipment. And if there's any money left over, to send them back that amount. And so what happens is the check that they send is a large check, meaning that there is amounts of money left over. Sometimes they'll even say that. They'll say, oh, well, we had a $2,000 allowance, but we have a check for $5,000 rather than us just reissuing it. Go buy your equipment and send us the $3,000 back. That's a job scam. The original $5,000 check bounces. By the time you learn that, you've sent back $3,000. So that's a frequent job scam. One of the ones I've recently seen is a scam to get your social insurance number. So I know the job search can be really, really exciting, and particularly for people who've been looking for a job for a long time, can be very, very exciting. If something seems too good to be true, or things just seem to be going too quickly, just keep your radar up. If you don't even have an interview, they just say, yes, we're giving you the job, please complete this information. And they're asking for things like, full name, full address, SIN, private banking information. Sometimes that can just be a scam. It can be, a scam to get personal information. Sometimes what scammers will do is will have you do an interview, but the interview is too quick. It's too soon. We're giving you the job. Yes. And, all the other jobs posted out there are paying $25 an hour, but this one's $30 an hour. And, it's very quick to offer you the job and have you complete the forms. That's not to say that legitimate employers who do hire you, ultimately at some point, you're going to need to give them your legal name and address. When they're doing a T4, they might even need your SIN. So at some point, your employer is going to need that. But if anything just seems like it's happening far too quick, interviews that you attend and they send you a Zoom link, but nobody's on the other side and it's just you on camera and the other person doesn't show their camera and very quickly offers you the job, those can be signs of a job scam. So I know that everybody's really excited for opportunities. Remote working opportunities are very exciting. New job opportunities are very exciting. Just don't forget to lose your common sense with those. Just, if it's too good to be true, sometimes it is. All right, well, jump right into the questions today. Now that we're back sort of into the swing of things and people are back from summer vacations, we might get a little bit more questions. So don't forget to write on in and put your questions in. I'm happy to answer those for you. For some of you that are routine watchers, please don't forget to like and subscribe so that you don't miss any of our live streams. Okay, let's turn to the questions. So question from Sacred Swordfish. I was terminated without cause after 2.5 years of employment and only offered 4 weeks severance. I believe this was due to me and a coworker not seeing eye to eye from the start. There have been unfounded complaints about my behavior and conduct. I don't believe this was a just termination and have documented incidents in the workplace. Am I owed more here? All right, thanks, Sacred Swordfish. Frequently we do see people who are terminated from the workplace because there are interpersonal conflicts. Oftentimes there are, unfounded complaints against an employee. And even though HR or the manager has decided that those are unfounded complaints, they can't continue to have interpersonal conflict in the workplace. Sometimes it's harder to find a new manager than it is to find a new, associate. So what they do is they let the associate go, even though it's not the associate's fault. So in those circumstances, what we have is a termination without cause. The vast majority of terminations are without cause. Just cause is a very high threshold. It's when an employee has engaged in significant misconduct that is so significant that the employment relationship cannot continue. In those cases, the employee doesn't get severance. But in a termination without cause, whether you got along with everybody great, whether you had a clear disciplinary record, doesn't really matter. In a termination it's called a without cause termination, meaning there is no just cause. All right, so there is no allegation against you. It's a no fault termination. You didn't do anything wrong to deserve the termination. And there is no such thing as near cause. When an employee gets terminated, their entitlement to severance stems from the requirement that the employer gives notice. Okay, Swordfish, your last day of work is 4 weeks from now. Most employers don't give notice. Obviously, if you give notice to somebody, you're not really going to get really good work quality out of them for the next 4 weeks. So most employers provide pay in lieu of notice or instead of notice, which is severance. So the entitlement to notice or severance is the same whether you have a slew of recent issues or whether you have a clear employment history. The only factors that really go into an assessment of how much notice or severance somebody gets is age, because it's harder to get a new job at 65 than 45. Length of service. Generally, long-serving employees get more notice or severance because the longer they're with one employer, the more narrow their skill set becomes to that employer. It also can mean it's been a long time since they've been in the job search market. The third factor is character of employment. So in order to know how long it would take somebody to find a similar job, we need to know what it is that they did. So their duties, responsibilities, managerial level of compensation, area of Alberta or Canada that they live in. And then the last factor is availability of comparable jobs in the marketplace. So in order for lawyers at Samfiru Tumarkin to assess your notice period, usually we need those factors because that is what guides us in doing an assessment of how long it could take somebody to find new work. So from Sacred Swordfish, we have one of his factors or her factors, that is, 2.5 years length of service. We don't know their age. We don't know what they did. If they're a manager, we don't know their level of compensation, and we don't know, sort of where in Alberta if they're working. If you're in Calgary, you might have an easier time finding a job than if you are in a smaller jurisdiction. So Sacred Swordfish, please don't hesitate to reach out. You can visit our pocketemploymentlawyer.ca that has an employment calculator for severance. And you can enter in those factors that we talked about. And then you can also contact us to have your severance package reviewed on an individual basis. So what we do all day, every day is assessing your entitlements. And so chances are, Sacred Swordfish, you probably are entitled to more. 4 weeks, it would be, unless you are in an industry that's very in demand, where you should be able to find a new job within 4 weeks. 4 weeks could be low. So we'd have to take a look at your factors. We'd also have to take a look at your employment agreement to see if there's something in your agreement that says how much notice you get. Now, as I've talked about before, just because your employment agreement has a calculation for how much notice or severance you get doesn't mean it's enforceable. It doesn't mean you're not entitled to more. We often see employers try and put termination clauses in employment agreements that would limit you to just your employment standards code minimum. So for sacred swordfish, that would be 2 weeks. So that would be 2 weeks. But obviously sacred swordfish, I'm assuming he doesn't have an enforceable termination clause because his employer is offering 4 weeks. Now the question is 4 weeks enough? So please don't hesitate to contact us. Go to employmentlawyer.ca, contact our intake team. It would be a pleasure to speak with you and assess your entitlements. Okay, next question from LaRose. I was terminated without cause on July 31st, and I'm currently negotiating a severance package. I expected my 2 weeks pay in lieu of notice today, but I didn't receive it. The company's lawyers keep including the pay in lieu of notice as part of the total severance offer, which feels like it's being used as leverage. Are they allowed to withhold the pay in lieu of notice during negotiations, or should it have been paid separately by now? All right, great question. So for those who may not be understanding the terminology we're using, pay in lieu of notice, so for the 2 weeks entitlement, is a statutory entitlement. It is a bare minimum amount of money that the employer must pay. Now, employers can pay more. So what I always say is it sets a floor, not a ceiling. It's just the mandatory minimum payment. In Alberta, employers have 2 payroll cycles or 31 days, whichever is greater, in order to pay the termination pay. Most employers don't take that long. Most employers will do it on either that day, the day of termination. You will also get your statutory termination pay. So LaRose should have already received it. Some employers will tack it on to the next payroll cycle. And so if you're in the middle of payroll cycle and you haven't caught the payment, it'll be on the next payroll cycle. For LaRose, it sounds like they're in a negotiation for the additional amounts. So LaRose is looking for the ceiling, but the employer is withholding the floor. So the 2 weeks pay that must be paid. It's inappropriate. It must be paid to you, and a record of employment should be issued indicating that you've received that pay. That does a couple things. It gives you the money that you're legally entitled to. It also helps you start your employment insurance application. So no, they shouldn't be withholding that amount. It should be paid to you even during the negotiations. And they have that period of time, 2 payroll cycles or 31 days. So if it feels like it's being used as leverage, you might be right, and it's inappropriate. Now, for clarity, when we assess how much notice somebody is entitled to, let's say we say that they're entitled to 2 months pay in lieu of notice, we are including that statutory minimum payment. So if somebody's assessment is 2 months pay in lieu of notice, if they've already received 2 weeks or should receive 2 weeks, that counts, and we're really looking to negotiate the additional 6 weeks pay. So I'm not sure if that's also come up in your issue, LaRose, but that is the case. When we talk about it, make sure that you are negotiating and talking about your full package, but ensuring that they do pay you your 2 weeks pay in the prescribed time by the Employment Standards Code. Okay, next question is from James. My boss and I kind of become friends. Because of this, he will ask me to do extra work, come early, stay late, etc. At first, I didn't mind, but now I feel like it's too often, and it's not a friend that I'm helping out, but a boss that's taking advantage of me. I don't want to cause drama or ruin the dynamic. How do I handle this? Okay, James, there are, certain employment scenarios in which people who are the ones who agree to accept work are the ones who get more work. And there's nothing from a legal perspective that prevents an employer from paying 2 people the same based on the hours of work and not their output. And so if you are a highly efficient, fast employee where you could finish your work in 5 hours, whereas your coworker takes 8 hours, unfortunately, your employer is going to sense that and will start giving you additional tasks so that you are doing, 8 hours of work for 8 hours of pay. Obviously, the hope and expectation is that those kinds of things will give you a promotion. If your employer is putting far, far more duties on your plate without changes in compensation, it could amount to a constructive dismissal. A constructive dismissal is a situation in which an employer is demonstrating that they no longer intend to be bound by the terms of the original employment agreement. So obviously employment agreements should be in writing, but sometimes they're not, sometimes they're oral. And we like that. We don't like employment agreements because they usually help employers. But over time, if you are getting more and more and more tasks on your plate without additional pay, your employer is demonstrating that they no longer intend to be bound by the employment relationship. Sometimes employers make changes like more money or a promotion, and we're okay with those changes. It's when an employer is doing something unilateral that we don't accept. They're making you do more work for the same amount of pay or the same amount of work for less pay. Those types of things are a constructive dismissal. So in those situations, if the change has been fundamental, so if we're talking about a significant change to the employment relationship, you may have a case for constructive dismissal. However, constructive dismissal is very nuanced. It is absolutely something that you should have reviewed by a lawyer before you assert constructive dismissal, because what we don't want is a situation where you are seen as resigning from your employment or refusing duties that your employer is allowed to put on your plate. So please reach out and have us assess your case on an individual basis at employmentlawyer.ca. So, James, I hope you reach out, because if you're concerned that it's a constructive dismissal case, that's certainly a legal issue that we can help you with. The other thing is, if it's just from a non-legal perspective and you're looking for some life advice, it's about whether, you want to be the person who goes above and beyond, because there's an expectation that it will lead to promotion, and you're not looking to leave your employment, but you're just looking to ensure that those things are recognized. That's certainly just a conversation you're going to want to have with your boss and say, I really hope I'm demonstrating my commitment to my employment. And then can we talk about what my future looks like? So if it's a legal issue, please hesitate to reach out. If it's a constructive dismissal, we can help you assess that. Okay, question on YouTube from Harry. I'm on medical leave and made it clear I intend to return. When I tried to initiate a gradual return, my employer suggested a demotion and pay cut, then delayed things by requesting more medical info. Due to health issues, I missed some emails. The last one warning of termination for job abandonment, which I only saw after the deadline. Could this be wrongful dismissal? The short answer of that is yes. It certainly could be wrongful dismissal. Harry has quite a few legal issues going on. These are exactly the types of legal issues that we're contacted about so that we can assess your situation. So there's a couple of things that we're talking about here. We're talking about whether the employer is accommodating a return to work plan. What that is when somebody's been off on medical leave and is able to return to work, but may have some limitations. So one of those limitations may be that they actually need a gradual process. Maybe they work less hours per day or less days in the week or both. And the employer has to accommodate that to the point of undue hardship. And so whether your employer is failing in their obligations to accommodate is the first primary issue that we need to have assessed by a lawyer. If they are, the issue is, have they discriminated against you? And also, have they constructively dismissed you? Just going back to sort of what we had with James is your employer demonstrating that they no longer intend to be bound by the employment relationship? Now, the second legal issue is job abandonment. So the legal test for whether somebody is leaving is, has this person, is there clear and unequivocal evidence that this person intended to leave their employment? We don't have that situation with Harry. Harry doesn't have a clear and unequivocal intention to leave his employment. He missed some contact attempts from his employer. So Harry, please feel free to reach out and contact us. We can help guide you through this situation. If the situation is, I want to go back to work, we can help you get reinstatement with back pay. If the situation is, no, I'm just looking for some severance and perhaps some human rights damages because I've been discriminated against, we can help you with that as well. Okay. We've got another note here. Laid off after 6 years teaching at an Ontario private college. No contract, only 6 weeks pay, and unpaid for 2019 to 2021 content I made, which college monetized. Am I owed common law notice and content fees? All right, so we've got a couple of issues there. So first of all, I'm an Alberta employment lawyer. So when it comes to Ontario entitlements, I can certainly help you if they're common law entitlements. If it's statutory entitlements, you'd certainly want to reach out to one of our Ontario lawyers. The other issue is that this person was a teacher. And so at least in Alberta, if you work as a teacher, you may have different entitlements because you may not be governed by the Employment Standards Code. Your employment may be governed by another piece of legislation. All right, so there's that issue. Now, the third issue talks about content that the college monetized, but it's from 2019 to 2021. So in Ontario, just like Alberta, there are limitation acts, which means that you have a certain amount of time in order to bring a claim. If you have an entitlement, we call those limitation periods fatal. It means that if you miss it, that there's nothing the court can do. The court really doesn't even have the jurisdiction to extend your time to file a claim. So my concern is whether the claim is even out of time, and whether what the entitlement is to those. Because if there's a question about whether those were part of your job duties, if it wasn't part of your job duties, what was the work done with an expectation of pay? And again, that sort of goes back to the earlier question is when you do additional duties and your employer is putting additional duties on your plate, is it coming with additional compensation? If not, it could be a constructive dismissal. So for this person who's writing in, the question is, was this part of your regular duties for which you have received your regular salary? Or was there always an expectation that these are additional duties for which you'd be compensated? So certainly reach out to see if there's something in your matter that we can assist with. All right. Question from Burrito Bo. After 20 months in my current position, marketing for a healthcare company, I've been terminated without cause. I was offered 2 weeks in lieu of notice, plus an added 4 weeks as severance. I had 2 weeks of unused vacation, but no mention of that in the package. Was wondering if that seems fair, if I could spring for a bit more. Okay, so there's a couple of issues, and I do thank Burrito Bo for providing a little bit more detail so I can provide an assessment. So Bo has been offered in total 6 weeks severance. So we've got a 20-month employee in marketing being provided with 6 weeks, so a month and a half. To answer Bo's question about unused vacation, that must be paid to you just like any unpaid wages. Vacation pay, if it's not used, it's accrued and it gets paid out at termination, okay? So yes, you can get that. Now for Bo, we have some information. So we have the length of service and the character of employment. We don't have age and we don't have where they work, so we don't know the availability of comparable jobs. But just getting a sense for marketing, The problem for Bo and the problem for a lot of people in marketing is not that you're not fully qualified and you're not totally competent. You're applying for jobs that have 1,000 applicants. You and 100 others are perfectly qualified for that role. So there's a lot of competition. There's a lot of qualified people for a very few amount of roles. Obviously AI has had impacts in the marketing industry, and the number of jobs has decreased. So based on the information that Bo was providing, I don't think it's enough severance. The other thing about Bo is that they were employed for only 20 months. Now, we always talk about length of service. Generally, long-serving employees are entitled to more notice or pay in lieu of notice. The inverse can be true for short service employees. Oftentimes, they get disproportionately more notice or severance. That's because you think about the way a resume may look to future employers. If you are hired and then let go within a couple of years, future employers are going to say, well, maybe this person just couldn't cut it in the role, and will pass your resume over for somebody else with a more substantial tenure. So Bo, to me, it sounds like you should be springing for more, to use your terminology. Certainly happy to assess your case. If you want to reach out, you've got our pocketemploymentlawyer.ca website. You can do your own little assessment on that calculator. And then we have this intake team that will help place you with a lawyer who has availability and practices in the province in which you were employed, who can help you assess your case on an individual basis. So it's why we're here. It's what we're happy to do. Please reach out and we will assess your severance entitlements. Okay. Question from Level Dot. Bonuses are given out based on the company's profits. We have received a very stripped down balance sheet in the past showing income/expenses/profit. Anyway, it's been 4 to 5 months now, and we still haven't received anything. We are told that there is no profit, but I believe that they're trying to sell the company. I have a compensations package contract. What are my rights in this situation? Bonuses are a really interesting topic. And we deal with them all the time because oftentimes people are getting terminated, and the question is, do they get part of their bonus, or is their termination severance entitlements based on their base salary only? Most often, the answer to the question is you are entitled to your bonus, whether it's prorated, whether it's any bonuses that would be paid in the notice period. So bonuses are certainly a hot topic with employment lawyers. So one of the issues we look at, and this applies to Level Dot, is what are the metrics for entitlement? Is it individual performance? Is it business unit performance? Is it company performance? If it's company performance, what is it based on? Gross income, EBITDA, net revenue, what is it based on? Because if you're sort of being treated as like a shareholder, are you getting a shareholder dividend, or is the company reinvesting that money in itself, meaning there are no, profits? It's saying that it's not a profitable year. So the other question that's relevant is, how many years have you received bonuses? If for the last 10 years you've received bonuses and you suddenly didn't get a bonus, we have to look at it. The other question is, what percentage of your income is a bonus? Are we talking, 1% of your income, 20% of your income, 500% of your income? Those are all relevant questions. So for Level Dot, happy to reach out. Just because you haven't been terminated doesn't mean Samfiru Tumarkin isn't here for you. We do help people with employment situations where they haven't been paid their bonus, or their boss is trying to change their compensation, or their boss is trying to give them a brand new employment agreement and they want that reviewed. Don't forget that there's lots of different situations where you might just need a 1-hour conversation with a lawyer, and reach out and we can assess your situation. So go to employmentlawyer.ca. You can find us on the contact page of how to set up a time to chat with any of our lawyers who are qualified in your area. Great questions today, everyone. It was such a pleasure to see you. I'll be back in a few weeks. We have Dan Balcaran tomorrow. Dan is in our Vancouver office, and so he's at live streaming at 10:30 a.m. Pacific time. Don't forget to like and subscribe so that you can find him immediately. Otherwise, I'll see you guys at the next one. Take care.